continued retention in office of Inspector General of Police, Kayode Egbetokun, in spite of his attainment of the retirement age of 60 and 35 years of service, has been generating controversy over the legal interpretation of his tenure. While the Police Act mandates retirement at 60 or after 35 years in service, another section guarantees a 4-year term for the IGP, and this has led to conflicting legal positions on the matter. Again, the Police Service Commission has just ordered the immediate retirement of all senior police officers who have exceeded 35 years in service or are above the age of 60. We're now joined by lawyer and a former president of the Committee for the Defense of Human Rights, Malachy Ugwummadu, to interrogate this directive from the Police Service Commission, as well as take a look at the criminalization of free speech by the IGP through the perceived abuse of the Cybercrimes Act of 2015 section on cyber stalking. Good to have you on the show. Thank you for joining us.
Thank you for the opportunity to be here again.
Well, a potpourri of issues here, of course, based on the elongation of the tenure of the IGP, Kayode Egbetokun. Now, we have conflicting acts, like we just read from the Police Act, and then the extension of service that says that he can stay for 4, or that, anyone appointed should stay for 4 years. But also, we know that President Tinubu approved that bill, that act that was passed by the National Assembly, that he can, be extended, the stay can be extended to 2027. Can you clarify for us what exactly the legal implications or interpretation of all of this is?
I like the word you used when you introduced. Said I'm going to interrogate it. I think we should stay with interrogating this, because it has not just become conflicting, like you said, it has become convoluted. And that is to the annoyance of Nigerians for so many reasons. The one being that there is so much tardy handling of this whole matter, no less the intervention of the National Assembly. But please, let me set the ground rules and clear a few grounds. There are just 3 provisions of the law that are relevant to this discussion. The one is Section 7, Subsection 6. That provision gives a certainty of tenure to the Office of the Inspector General of Police and says that anyone who is appointed, who occupies the office of the Inspector General of Police, shall be there for 4 years. Certainty of tenure. But he says it is subject to subsection 8(6). When you say a provision is subject to another, it means that other provision is superior to the one you have just read. So what does 8(6) say? It says every police officer, every police personnel in Nigeria, including the Inspector General of Police, shall cease to be in office or shall retire once he once he has served for 35 years or has attained the age of 60 years. So it is immaterial whether you have a certainty of office for 4 years. Once you have served for 35 years, or you have attained the age of 60 years, whichever one comes earlier, you have to go. These are the 2 operational provisions of the Constitution that clearly, in your word, ran in conflict with each other. Because what they try to do is to create a certainty of office for the IG and left vulnerable every other police officer. When the National Assembly noticed that, they tried, but in my view, unsuccessfully, to solve the riddle by amending just in September last year and introducing subsection 8(8)(a). What does that say? It says, notwithstanding that provisions about 35 or 60 years of age, once a person is appointed to the position of an Inspector General of Police, he shall remain there for the period of 4 years as specified in his letter of appointment. So the issue now, the problem arose because in the desperation of the political class to protect one of their own, they have gone ahead in one fell swoop to create two provisions relating to just an Inspector General of Police. The one is the one that say you can be there 4 years, and then made it subject to the one that says you must go if you have served for 35 years or 60 years, whichever one comes earlier. When they saw that that is shooting themselves in the leg, they said, no, it's no longer the law. We have amended it to mean that that 4 years shall be what your letter of appointment discloses. So this confusion is the problem that drafters of law in clear constitutional arrangements and democracies, legislative drafting is an act that requires the best of skills. The big problem in legislative drafting is when you target a particular person, either to save him or to punish him. Once you do that, you will need to keep amending that law because you will run foul. No wonder we have just heard that the Police Service Commission have now said, so in one breath, the IGP is in trouble, at least in the eye of the public. In another breath, the same police institution is crying foul that people have stayed beyond the 35 years of service and 60 years of age. This is the controversy.
Now, you've actually explained a whole lot, but, the Attorney General of the Federation, he has attempted to wade into the matter, and he says that Egbetokun's continued stay in office is legal and lawful due to the amendment of the Police Act. But then isn't this amendment setting a dangerous precedent, where you amend the law to support what ordinarily is illegal? And with such a high-profile person involved, the Attorney General, defending this, how then do we challenge, what some people believe is an illegality?
So, with profound respect, and Prince Fagbemi has been doing quite a lot since he assumed office. But he's not the court. And if we no longer find reasons to disagree with ourselves, we can as well close shop. I don't agree with the Attorney General of the Federation on this one. However, the law is already there. What I disagree with is that it is tardy. It is not promoting any coherence and coordination in the operation of the Nigerian police force. And I say this with profound respect because as it is now, think about what the confusion is already, the confusion that has already set in the Nigerian police force. They are very intelligent police officers I know in this country. Many of them with doctorate degrees. Thousands of them lawyers. So in one breath, they read the provisions of the Act as amended. They see the poverty of the situation as the ruling class, that is the political class, makes desperate attempt to protect just one person to the detriment of the rank and file, the totality, entirety of the men and officers of the Nigerian police force. I think that is where the problem is. So whereas you see the law in black and white and also harvest the controversy that it has generated, and I think we should give some kudos to Omole Sowore. It is him, courageously, who is pointing out this. The fact that the National Assembly has gone ahead, if you like, without serious tact and sensitivity to the state of the nation and the implication of that to security, amended the law in a way that they have now exposed the poverty of the situation, in my view. Because, come to think of it, Section 7, Section 6 says the tenure for the IGP shall be 4 years. The same act, and remember, this is 2020 Act, 2020 Amendment Act, the act that was amended after about 74 years. So you have a National Assembly that made that section subject to another section that says every police officer It didn't say, with the exception of the Inspector General of Police, shall retire if you have served 35 years or if you have attained the age of 60 years. On record, on verifiable record, the Inspector General of Police, fine gentleman, I mean, I personally was very impressed with the way he was carrying on. But the law is the law. He has attained 60 years. He cannot be immune from the law. So in September, this same law was now further amended to say it is immaterial whether Section 7...
I think that was in July last year.
Oh, sorry, if it's July.
Yes.
Because the president now issued. It is this new... In other words, appointment is not strictly based on the law now. It is based on the instrument of appointment. That is the letter. If the letter communicates, which is what it is now, that he will now, from that moment, serve 24 years in 2027. This is where we are.
Thank you, Mr. Ugwummadu. Now, looking at the issue of Omoyele Sowore, which you just mentioned, perhaps if you had not, challenged and called or alleged that the IGP was illegal, all of this wouldn't have come up. And it's sad that we have to go through that route to find out all of these issues. But look at the charges that were,
Let me talk about that a bit before we go to the charges. I said we need to commend him. Some of these things don't come cheap. And it also exposes the level of insensitivity that all of us have, if you like, collective amnesia. Because if we were more interested, if we were more vigilant, that's the word, we would have seen through all of these permutations, which has now suffered legislative intervention. Now, you and I know that the retirement ages for judicial officers have been increased, particularly judges and justices of the appellate court, 65 years to 70 years. Were there hues and cries? None. What about lecturers? Again, 65 to 70. So why has this one generated so much controversies? In my view, and I'm speaking as one who leads a community of rights advocates and campaigners, the slogan is that liberty, our liberty, is perpetually upheld through our vigilance. If we lower the guards, as we have done in this case, I don't want to talk about public hearings because I didn't hear any. So how was it possible to churn out these conflicting, I said just 3 sections. Section 7, subsection 6. By the way, it took Nigeria about over 7 decades to amend the Police Act. So in 2020, when we ought to have gotten our ass very clearly, we introduced just 2 sections. Section 7, subsection 6, and then section 8, subsection, section 7, subsection 8, and then 8, subsection 6. The National Assembly, knowing that the conflict already exists, tries to save one of their own. That is what it is, because the amendment gave the president the legal foundation to now assent to an instrument that has now become by far more potent than the provisions of the Police Act. In effect, Ugwummadu owes his tenure to that letter. And so that letter is now more powerful in terms of certainty of tenure than the Nigerian Police Act 2020.
Now, I'd like us to talk a bit, about the Cybercrimes Act of 2015. Some people believe that the IGP has been misusing this act, to criminalize free speech, and that he is attempting to silence critics of the government, as we've seen, with Omoyele Sowore. What do you say on this?
My take on this is that, the Nigerian police should moderate their, if you like, overzealousness. And I'm using my words carefully. This is coming against the backdrop of the frustration we face as citizens of this country who have suffered the failure of leadership, including police leadership. And that is as a result of the level of violence we witness on a daily basis. So if you have all of those as issues that Nigerians are contending with, and you now see the same Nigerian police were becoming so aggressive with respect to one aspect of the legislation, granted that their duty is to enforce the law, it is clear. But the Nigerian people need to know that there has been also an amendment to the Cybercrime Act. Yes, that amendment, the controversial section of the Cybercrime Act is section 24. And what does it talk about? It talks about if you knowingly and intentionally, in law, meaning the mens rea, that is the mental knowledge, must be present in interpreting whoever you claim has violated that provision of the law. If you knowingly and intentionally uses the computer in either bullying, cyber stalking, this, that, you will be guilty of this offense. That section was amended for a particular reason. It is that the wholesale implementation of that section will have a direct effect on the rights of Nigerians to freely express themselves against the provisions of the Constitution. And you and I know what the law says when a law comes in conflict with a constitution. It says the provisions of the Constitution will prevail. If any law is inconsistent with the provisions of the Constitution, that other law, in this case, Cybercrime Act, is an act of the National Assembly. It's not the Constitution. The Constitution grants you and I the right to freely express ourselves. It does not grant us the right to injure any person or defame any person, but it says we have a right to express ourselves. So that law was now amended, removing all of those angles, leaving only designation of pornographic materials. That is the only thing contained in section 24 as of today. So this whole exuberance and, if you like, the excessive application of this law at the whims and prompting of the Nigerian police have become totally unacceptable. And we say this because we see abuses. We see abuses of that power. First is that that law no longer exists in the form and manner it was originally enacted. Section 24 of the Cybercrime Act has been amended, stripping that section of all of these things they're hanging on to.
So is this an indictment on the judiciary? Looking at the fact that the Omoyele Sowore was alleged with cyber crimes, and of course it was granted bail, that's 10 million naira bail. Is this, since you say that all of these have been abused or misinterpreted some kind of way, is it an indictment on the judiciary? Because it's been prosecuted in a court of law.
No, on the contrary, it's an indictment to the law enforcement agencies. The judiciary is there to absorb every charge that is brought. It behoves the defense counsels to point out the position of the law to the court, and the court will know the law. As I'm talking now, the judiciary is aware that that act has been amended. So come with your charges. Load your charges with all of these allegations that have been dropped, and then the judiciary will interpret. So it is for us now, as rights organizations, right activists, to consistently begin to point out some of these anomalies and insist that the excesses of law enforcement agencies should be curtailed, at least moderated, and then take the bigger step, which is contesting the propriety of what they do sooner than later. And that way, we'll get, it's a society, it's work in progress, and it comes by contest. Democracy is actually a contestation. It is a contestation where you come with your view, I come with my view. But because we all need to survive in this space, we contest it. So it's a forum for contest, now, whether on the street or in the courts.
Definitely. Well, some people believe that the act has now been weaponized, against free speech and responsible journalism. In such a situation, how do we begin, to protect the rights of citizens, the rights of journalists, the rights of, activists who have been targeted, with this act?
First is the courage of our convictions to say that I'm not going to back out because in the hierarchy of laws, the Constitution is by far more superior than legislations, no less bylaws. So if you have a legislation that is an act of the National Assembly running amok and in direct conflict with the provisions of the Constitution, we'll strike it down by contesting it. Secondly, talking about the journalists, there are several judicial authorities, one involving Atonwanko and state, in which this whole thing, a lead has been provided that if you feel bad about one's exercise of his right, the only option you have is not to criminalize that, is to go to court, you that feels bad about it, and contest it, either by way of seditious, by way of defamation, libel, or slander. But to criminalize it, we have passed that stage. Secondly, is the sensitization that we're all doing. That sensitization tells Nigerians that, look, you don't have in the body of laws legislations which is at a lower level in terms of the superiority, the priority, the ranking of laws, conflicting, challenging the provisions of the Constitution. The Constitution talks about your freedom to freely express yourself and communicate. That is why it is only pornographic materials that are left in Section 24.
We'll have to leave the conversation there. Apparently, there is still so much to clarify, especially the legal perspective to this issue. We must appreciate you for the robust analysis on this issue. Lawyer and former president of the Committee for the Defense of Human Rights, Mr. Malachy Ugwummadu. Thank you for your time.
Thank you for the opportunity.